Morning, everyone. We are convening the Joint Committee on Commerce, Consumer Protection and Commerce and the Committee on Judiciary and Hawaiian Affairs. It is Thursday, February 13th, 2025, 10 a.m. at conference room 329. We have one, I'm just going to go right into it. We have one item on the agenda today, HB 982 HD1 relating to wildfires. Before we get into it, though, let me read a quick script. In order to allow as many people to testify as possible, there will be a 2-minute time limit per testifier. Because morning hearings must adjourn prior to floor session, not all testifiers may have the opportunity to testify. In that event, please know that your written testimony will be considered by the committee. For those on Zoom, please keep yourself muted and your video off while waiting to testify after your testimony is complete. The Zoom chat function will allow you to chat with the technical staff only. Please use the chat only for technical issues, especially if you disconnect. If you are disconnected unexpectedly, you may attempt to rejoin the meeting. If disconnected while presenting testimony, you may be allowed to continue if time permits. Please note the House is not responsible for any bad internet connections on the testifier's end. In the event of a network failure, it may be necessary to reschedule the hearing or schedule a meeting for decision-making. In that case, an appropriate notice will be posted. Please avoid using any trademarked or copyrighted images. Please refrain from profanity or uncivil behavior. Such behavior may be grounds for removal from the hearing without the ability to rejoin. And also, for testifiers, I know we'd like to stand on our testimony sometimes. Please come up to the mic to stand on your testimony just so everyone on Zoom and YouTube can hear you. All right. First up, for HB 982 HD1, Department of Commerce and Consumer Affairs with comments.
Good morning, chairs, vice chairs, members of the committees. I'm Nadine Ondo. I'm the director of the Department of Commerce and Consumer Affairs. We stand on our written testimony offering comments on this measure and will be available for questioning.
Okay, thank you. Next up, we have DCCA Division of Consumer Advocacy with comments.
Morning, Chair, Vice Chair, members of the committees. My name is Michael Angelo. I'm the Executive Director of Division of Consumer Advocacy. We stand on our testimony providing written comments available for questions. Thank you.
Thank you. Next up, we have the Public Utilities Commission with comments.
Chairs, Vice Chairs, members of the committees, Leo Asuncion, Chair of the PUC, will stand on our written testimony providing comments and will be available for any questions you have.
Thank you. Next up, Attorney General with comments.
Good morning, Deputy Attorney General Randall Nishiyama. We've submitted our written comments and are available for questions. Thank you.
Okay, thank you. Next up, IBEW Local 1260 in support.
Morning, Chairs Matayoshi and Tarnis, Vice Chairs Chan and Poi Poi, committee members, Kika Bukowski on behalf of Leroy Cincio and IBEW Local 1260. We just want to thank you folks for hearing this measure. We want to state for the record that this bill is very important to our membership. This bill will have a direct impact on our local union as well as our membership. And we just want to reiterate that we understand that there's a lot of thought and a lot of work that's been going into this bill as it's moving forward. But we would respectfully request that you consider amending Section A3, subsection B, 1 and 2, and reinstate the language that was in the original draft of House Bill 982. Thank you.
Thank you. Next up, we have the Chamber of Commerce in support. Not present. Next up, Kauai Island Utility Cooperative in support, KIUC.
Yes, good morning, chairs, vice chairs, and members of the committee. Beth Amaro with KIUC. We do stand in support of this measure. We stand on our testimony and are requesting one amendment. And I'll be happy to answer any questions if needed. Thank you.
Okay, thank you. Next up, we have Ulupono Initiative in support. It says in person, but are they on Zoom? No? Okay. Not present. Next, we have Clearway Energy Group in support.
Good morning, Laurie Lum on behalf of Clearway Energy Group, and we will stand on our testimony in support. Thank you very much.
Thank you. Next up, Hawaiian Electric in support.
Aloha and good morning, chairs, vice chairs, and members of the committees. Jason Ben, Senior Vice President for Hawaiian Electric, testifying in strong support of the original version of HB 982 and expressing concerns with the HD1 version as relates to additional required contribution by Hawaiian Electric. This bill is in the public interest. It protects the people of Hawaii and our economy from the risk of future catastrophic wildfires. And despite immense and continuing efforts by many to reduce the risk of wildfire, including our own work, no one should assume the risk is zero, and we must act now. I want to emphasize that the bill is forward-looking. I want to make clear our company's commitment to pay its share of the $2 billion to our $2 billion share of the global settlement with no contribution for our customers. The HD1 requirement for an additional shareholder contribution of $500 million is simply not feasible at this time and would delay or prevent the fund from operating, thereby negating its benefits, including providing the intended credit rating support that would lead to lower costs to customers. Comparisons to California on this issue are out of context and not apples to apples for many reasons. In California, utility customers are paying for claims from past fires, claims from past and future fires up to $1 billion in damages, and contributing to the wildfire fund. As designed, the original version of the bill creates a wildfire recovery fund that reasonably balances the interests of many stakeholders and achieves three key objectives. It protects property owners, renters, and insurers and economy from future wildfires, and it protects customers from cost increases caused by the utilities' exposure to unlimited wildfire liability, and it preserves accountability for wildfire risk mitigation. The HD1 amendment unbalances these objectives and is likely to prevent or delay its implementations. Utilities must serve despite risk factors that are not all within their control. Simply put, unbounded wildfire liability risks results in bad credit, high cost of capital, which in turn leads to higher costs to customers at a time when we need to make critical infrastructure investments for safety, reliability, resiliency, and to meet the policy objectives of the state of Hawaii. Prior to August 8th, Hawaiian Electric's credit rating was A-. Its current credit rating is investment grade, below investment grade, speculative, and the lowest in the U.S. amongst regulated utilities. This bill is critical to begin the process of returning to investment grade and reducing costs to customers, and it includes a unique give-back feature. We request that you please pass HB 982 HD1 with modifications to restore the original language regarding shareholder contribution. Mahalo for allowing me to testify in support, and I invite any questions you may have.
Thank you. Next up, we have Par Hawaii in support.
Aloha, Chair, Vice Chairs, members of the committee. My name is Eric Wright. I serve as president of Par Hawaii. We're in strong support of this bill. One of the underappreciated aspects of this legislation is the benefits that it would have on a lot of local companies, including ours. We're the fuel supplier to Hawaiian Electric. It's a very capital-intensive business. At any given time, we have a lot of working capital tied up. And to pay our employees and contractors, we rely on timely payments from Hawaiian Electric. Likewise, there's a lot of independent power producers on the grid. Right next to our refinery, there's Kaliloa Partners, which is really critical to the power grid on Oahu. They're in a similar position where they rely on timely payments from Hawaiian Electric, and there's a host of other independent power producers like that. And then, of course, there's probably hundreds of different contractors and local businesses that do business directly with Hawaiian Electric, and all those businesses also rely on a healthy Hawaiian Electric. So we think that this legislation is good for Hawaii, good for the people of Hawaii, everybody who works here and does business here. And I'm happy to answer any questions. Thank you for the opportunity to testify.
Thank you. Next up, we have Life of the Land in support.
Aloha, chairs, vice chairs, and committee members. Life of the Land recognizes that this bill is a work in progress and that something needs to emerge to protect the utility and to guard against future catastrophic wildfires. We do note a couple points. One, the bill says that a catastrophic wildfire is a wildfire that burns down a certain number of buildings. as opposed to a wildfire that kills a certain number of people. So we would like the language changed to reflect that a wildfire that kills 100 people is catastrophic, even if 500 buildings don't burn down. Second, the bill talks about prudency review, and we note that while the bill is forward-looking, the Public Utilities Commission has not done a prudency review on a recent catastrophic wildfire. Mahalo.
Thank you. Next up, Charter Communications with comments.
Good afternoon, or good morning, chairs, vice chairs, and members of the committee. My name is Rebecca Lieberman from Charter Communications. Thank you for the opportunity to provide comments. Charter understands the intent of this bill and the desire to quickly and efficiently resolve claims stemming from catastrophic wildfires, but we can't support the bill without several important amendments, which are detailed in our written testimony. But we think the most important amendment is one that will ensure the bill is not construed to waive third-party indemnity obligations owed by participating electric utilities. As written, the bill would impair the contract rights of entities like Charter that attach broadband and communications infrastructure to electric utility property. If left in its current form, the bill may be rendered unconstitutional due to the abrogation of existing contract rights. Other requested amendments are related to joint and several liability, qualified damages, venue and administrative exhaustion, and I'm available for questions. Thank you.
Yep, thank you. Next up, Hawaii Association of Justice in opposition.
Aloha chairs, vice chairs, members of the committees, Evan Oy on behalf of the Hawaii Association for Justice. We do stand in opposition to this measure, and you have a written testimony. I apologize that it was late, but our primary points of concern are, of course, the liability caps on the limitation on liability that for those who reject from the fund. And we've always held that liability caps are bad public policy from our point of view, and the victims of these wildfires should be able to seek full remedy in these instances. Second, our second point of contention is going to be the ED that's created in this measure has substantial authority without clear parameters. For example, there's no guidelines on how these offers will be made, and then secondly, there's no express statute of limitations in there. So it does create concerns for when those victims are going to be filing. And then the third primary point of concern that we have is unclear language regarding damages that exceed the cost that's obligated to the fund. There's no rules or requirements that substantial payments shall be required in these instances. So if the obligation goes, the amounts go over what's obligated to the fund, it does create concerns on the, victim's ability to seek recourse. So, for these reasons, we respectfully oppose this measure and will be available for any questions.
Okay, thank you. That's all the testifiers we have signed up to testify. Anyone else here to testify on this measure? Anyone on Zoom? No? All right. We'll do questions. Do you want my committee to start, or do you want to just both, or up to you? Okay. Anyone have any questions? Okay, I guess it's just me. Kiko. Chico, you can come too if you want. So how did this $1 billion securitization amount number come to be?
Yeah, it's a great question. As I was trying to explain, we're trying to balance a lot of interests. We think that's a reasonable amount. The CAT's actuary study puts the annual risk at $1.4 billion for the state across every hazard, including hurricanes, tsunamis, floods, lava flows, and wildfires. We have our own independent analyst who said we've reduced the risk by 60%. It's consistent with what he thinks is the appropriate number. Yeah.
Okay, so it's not, because the point of this bill, although we are worried about wildfires and we appreciate you mitigating them, is to try to improve your credit rating. Has there been any indication from the credit rating agencies that $1 billion is an appropriate amount? Too much, too little? Have they given you any indication on that amount?
Thank you, Chair, for that question. Clearly, they'd like it to be as big as possible. We're trying to balance the interests here, which is why the combination of what we think is a fair and reasonable aggregate cap plus the $1 billion we believe is a critical first step to restoring our credit rating. So yes, they've indicated that the aggregate cap is important, but they'd like to see as large a fund as possible.
I mean, as large as possible is pretty vague, though. They
Yeah, it is
haven't given
very
you
vague.
any indication. I mean, if this came at 10 million, would they still be saying that's not, I mean, clearly at certain points, can you give us some kind of guardrails here?
We think this amount is the right balance. And
But it's
that
not based on any credit rating
agencies would prefer to see it be larger, but but they're also find the aggregate cap as the most important. We think it's the right level. Yeah.
Okay,
And
so
they have provided guidance that having a fund like this would help. Having an aggregate cap would be even more important.
okay, so if we did the aggregate cap with a $500 million securitization, you have had no indication from the credit rating agencies if they may consider that insufficient.
They would probably consider it insufficient, but their priority is the aggregate cap.
Okay, but how do we know they're not considering $1 billion insufficient too?
It's a fair question. You know, in our talks with them, they thought this was at least a reasonable level, but they are advocating for more. So
And they're always going to advocate for more.
that's my point.
But my point is, if we're at 500 million, they might be saying the same thing. This is a lot of money.
I would say that yes, it is. It's a serious amount of money. Yes, I think they would say 500 is inadequate. I think we can get there at 1 billion with the aggregate cap as designed. I think it's the fairest, reasonable balance. I think there's 3 things that have to happen for our credit rating to approve this bill with the aggregate cap and some level of backing to provide some insurance layer. We have to finalize the settlement of the claims, and we have to continue to work with everybody to drive down wildfire risks. All 3 things have to happen. When we saw our credit rating dive from A- to junk, it happened overnight. It took us years to climb up, and it's going to take steps, but this bill is one super important step to get there.
I understand. But my point is, if they're saying it's insufficient and needs to be higher at $1 billion, why are we putting it at $1 billion? It seems, why are we even doing it if they're going to say
I'm not
that's
sure
not
they
enough?
said it was insufficient. I don't believe that's what they said. I think they said they needed to see a fund. They were coy about exactly how much. They indicated they'd like to see a higher fund, but they said having a fund with an aggregate cap is the right step towards improvement.
Okay, an aggregate cap, but the $1 billion has nothing to do with the aggregate cap. So the aggregate cap could be in place, but it could be at 500 million. I think we need more clarity on the final amount, and I think we need that to be based on some kind of opinion by the credit rating agency that we're trying to influence.
We're happy to
Otherwise, this is
provide
really
their
just a shot in the
opinions.
dark. So that concerns me. I mean, I know you're concerned about the $500 million split that the previous committee put in, but to me, should it even be $1 billion? I don't know, and it sounds like you don't know either. So I think we need, anyway, I know you don't know, you don't have an answer for us on the spot here. Before the next committee, I really think you guys need a better answer, though, on how that $1 billion came to be and whether it's actually going to be sufficient to move any minds. Because I don't want to put this $1 billion in place here and then have it not do anything on the other end. That seems ridiculous to me and frankly, very destructive.
Sorry, could you repeat your last?
And very, very destructive to ratepayers. I mean, if it's not going to move the needle, why are we doing it? So if you could get a better response by the next committee, and if you get one before, please send it to me and I'll
We will do
distribute it
that.
to the
We have
committee
some
too.
reports for them. I just don't have them with me, and we will follow up exactly as you said.
Okay. As far as securitization goes too, do you need this bill in order to request securitization of this amount from the
Yes.
PUC?
If we went through a normal rate-making process, we wouldn't be able to do a bankruptcy remote securitization. We need it legislatively, and we've calculated the cost of doing it that way over a 5-year period or through an amortizing bond at 2 to 3 times the amount to customers. So instead of 4, it would be 8 or 12.
So if we set up the wildfire recovery fund and we did limitations on liability, basically all the A portion of this bill, would the securitization itself, though, be able to be requested from PUC directly by HECO?
We have to go to the PUC even after you approve this bill for a financing order, I believe. But
Yes.
yeah, legislatively, we would need it approved here first.
Which kind
allowed
of begs the question, though, if you need to go to them after this bill anyway, why are we doing this bill?
Because without the legislation, it
Or,
won't.
I mean, the second part of this bill, I should say.
The securitization you're asking about. Without legislation, it's not impervious to a reach down in the event of a bankruptcy. It's not bankruptcy remote, which means we won't get AAA credit rating on the securitization without the legislation.
Which part of this bill guarantees that or secures that? Is it the Wildfire Recovery Fund establishment itself?
The securitization through the legislature makes it a surcharge that is remote from bankruptcy, low risk, a low risk investment. So creditors will loan us the $1 billion at a super high credit rating.
And PUC won't.
Their OK alone doesn't give us the risk reduction that the people who would loan us the money would give us that financing at that low level.
Is that using the state's bond rating,
No.
or is that?
No, I don't
Okay.
believe it's.
Is PUC
No.
here?
PUC,
Can you provide further explanation as to that? The bankruptcy protections, I guess?
To be honest, I don't know everything about the bankruptcy and what that process may entail. But basically, we would be doing the financing order, right? The way I read the bill as is, this is very different from last year's bill where we did have, right, the state's, using the state's credit to try to borrow the money. This one is all on HECO, right? So what I'm hearing is, right, there's a number of factor of things that need to happen. And, right, at some point, right, HECO becomes investment grade, right? Might not be A, right? And at that point, right, that's where they're going to have to borrow the money at that rate, right? It's basically to lift them out, right? Kind of lift them out of junk bond status and get them to a point of that they are investment grade,
Right.
and that would be the rate.
But
If
that, sorry, I feel like we're getting off topic though.
Yeah.
For the bankruptcy portion though, you have no opinion on it?
We do not have an opinion on it. We do have bankruptcy counsel on retainer because we've been preparing for, just the just in case part. We could try to get back to him and see, and give the committees that information, but.
Okay, let's see with, Hiko, do you have a follow-up response?
thank you, Chair. Just following up and hopefully providing clarity. With the legislation, the credit rating is based on the fact that it's a dedicated revenue stream and making it risk-free to people we would borrow the money from, but we would do the borrowing. So legislatively, that $4 charge is isolated from all other creditors, and therefore we can achieve the highest possible credit rating for that, which reduces the cost of it. And secondarily, and I take a moment to point this out, it effectively provides us with a much cheaper alternative to insurance, which is a normal cost of business that would be normally part of rates. But because it has this dedicated revenue stream, we can borrow against it at a much lower credit rating. Does that make sense?
Some of it does. I feel like if you enter Chapter 11, the bankruptcy court could still reach the $4. I'm not sure how this is around at that unless you're taking it outside of your corporation.
Yeah, it would be, my understanding is would be an isolated legal entity that has similar to GEMS, yeah. We can
Okay.
follow up for
Okay,
you, Chair,
okay.
on that, but I mean, it's isolated, it's revenue stream, dedicated revenue stream, it's isolated from our other revenues. And
The revenue stream would go straight to the trust? Is that how it would work?
Revenue stream would, no, the revenue, yes, the revenue stream would pay for the financing of the fund. Pay for the financing of the fund. We certainly can clarify
Okay.
for you, but it's been done in other states and it's been proven effective in many other states.
Okay. Has it been tested in bankruptcy court?
I don't know. I will follow up on that, or can we make sure to follow up? We'll follow up on that for you.
Okay, that is a more compelling reason to grant this bill, that's why. So, yeah, if you could follow up, I'd
We'll do
appreciate it.
that.
So if we kept with the current version of the bill and we did the 50-50 split, which I know you folks are against, how would that affect the approximately $4 securitization fee?
I mean, simple math, it would be half, I would think, yeah.
Okay, and where would, I I'm
I
trying
think
to throw
that-
you a softball here.
Yeah, I'm sorry.
For the amount that the ratepayer would be paying on the other end, aside from this fee, though, would that go up significantly?
It would delay the improvement of our credit rating, which would mean sustained high cost of capital, which will drive all of our unit cost up across all our borrowings and every piece of work we do. Without some help to improve our credit rating, all we're doing is delaying. The PUC has said in their testimony, it's not dispositive that the bill will cause an automatic return of our credit rating. It is true. I mentioned the 3 steps. But it is certainly dispositive that we won't get back there without. The bill is really to the benefit of the customers. The charge is offset once we restore credit rating by quite a bit. And in our testimony written, we give you the difference from our current and over the projected borrowings we have to do. And as the gentleman from PAR said, we're in a very capital-intensive business. So everything we will be borrowing at junk.
So you're saying that even though the $4 increase will be kind of line itemed on the ratepayer's bill, the overall effect of the net that they're paying on the bill would probably be going down more than the $4 it's increasing?
That's what I'm saying.
That
Once
makes
we
sense in
restore
that,
our
but-
credit rating, that's what I'm saying, yes. And we won't get there without this bill.
Okay.
Our ability, go ahead, sorry, Chair.
Oh, no, please.
I was just going to say, I mean, we really have asked shareholders to contribute $2 billion without any claims. People are drawing this comparison to California. It doesn't work. It's a completely different fund. And it would be exceedingly difficult for us to make a significant contribution at this point, which is going to delay any improvement in credit rating for our customers. Yeah.
That's actually kind of where I was going, though. The California, as I understand the California fund being set up, it was a 50-50 split.
Yes,
You
sir.
had said that one of the differences is because the California electrical companies were dealing with past liability as well as future,
Yes.
which sounds like exactly what you guys are dealing with, right? I mean, I'm not sure why it would be fair for California to do a 50-50 split, but not fair for it to happen that way here.
Thank you for that question. And if you'll allow me, I'll attempt to explain. Okay, so in California, they established a fund in 2019. All previous fires, they're allowed to apply to their PUC to recover in rates. And just 2 weeks ago, the California CPUC increased the bill for all SEC customers by $1 to cover the 2017 Thomas fire. Okay, and they have a docket in front of them now to recover the Woolsey fire damages in rates it's about triple the size, about $5.6 billion from that fire that they're seeking to recover. Even as we go forward, the California Utility Wildfire Fund has a $1 billion attachment point. So PG&E is seeking relief for claims for fires below $1 billion. And then secondly, the Wildfire Recovery Fund in California serves one purpose. It reimburses the utilities for their legal fees for settlements and judgments. It doesn't have an administrative process. People in the Camp Fire from 2018 are still waiting to get paid. So it's a vastly different bill. In our case, the vast majority of this is being paid through what we agreed. Let's help the community move forward. Let's settle. We settled at $2 billion. We're paying for that out of shareholders. In this legislation, we forego our right to defend liability if the fire involves our equipment. So there is a balance of interest, Chair, that we're trying to meet. Does that make sense to you?
Yes, that makes sense.
Thank you.
Rep. Lowen, did you have a question too?
Well, when you're ready.
Yeah, if it's following up on this, please.
Yeah.
Or is it something totally different?
It's related but a little different.
Oh, no, go ahead.
No, I'm totally shifting gears, so you finish.
That's fine. I'm done with that line of questioning.
The current bill, I mean, it's a little bit related. We're talking about the amounts, right? The split between shareholders and ratepayers. So the amount I had kind of a two-part question. Well, never mind. Okay, I'll try to be clear. If it stated the current amount, the 500 million contribution, well, 505 million from shareholders, or even if that, shifts down or shifts up as this bill moves forward, I mean, what would Hawaiian Electric do to raise capital? Would you issue stocks, look at selling off assets? Like, what would be the avenue you would move forward to do that?
So could you restate the front part if you're saying if the contribution stayed the same?
Well, just assuming, I mean, your position is to go back to just the 5 million for administrative costs.
Yes.
If we pass something that requires the 505 million,
Right.
you know, or maybe it's 605 million, or maybe it's 405 million. I mean, what will Hawaiian Electric do to raise capital?
So thank you for the question, Representative, and respectfully, we still have to raise another 1.5. We've divested many assets, including American Savings Bank. Our market cap is just slightly above what we have to raise to finalize the settlement. We're confident we can do it. We're also fairly confident we won't be able to raise more funds that are not returning to investors. So shareholders have lost 3/4 of their investment already in the value of the stock. They've lost dividends for a year and a half, and they're being asked to raise $2 billion, which will have no return on equity to them. We just don't think it's feasible to raise additional monies that are going to be a significant contribution at this point. So,
What if you sold Helco or Miko or something like that?
I don't think that's an option. I don't think it would help. The company that remains would still have the same liability risk, and they'd be in front of you asking for the same bill and asking for it to come from customers. We'd just be selling the liability.
Okay. And how does the court settlement affect your credit rating?
I don't think the court
Or
settled.
the court's decision on the settlement?
So it doesn't finalize the settlement. The trial court still has to see it through the end. I think we saw a slight bump in the stock value. It's not doing anything for the credit rating. We need all three elements to be proven, which is that the settlement is finalized, that there's some protection for creditors and for investors in the form of this bill. And then we have to keep doing what we're doing. We prioritized, without raising rates, $130 million last year to bring the wildfire risk down by 60% across our service territory. So we have to make these investments. I can't stress enough, the sooner we can get our credit rating back, the cheaper it will be for customers, and it will offset the $4.
I want to get to Rep. Iwamoto, but I want to follow up on one of her questions first.
Yes, Chair.
Rep. Lowen made a good, or an interesting point, I thought. I guess good is relative to who's hearing it, but selling off a part of HECO, Helco, Maui Electric Company, I mean, you're right that that entity would still have that same kind of forward-looking liability, but you would be cutting off liability from yourself too. And then the money being raised wouldn't necessarily come from ratepayers, as you're saying. It would be coming from an outside investor who would then, theoretically, have the funds to deal with that forward-looking liability, which they would consider in making that purchase. Have you considered divesting yourself of certain pieces of HECO to co-ops or otherwise to allow you to not only divest yourself of some of the liability risk, but also to raise capital from a third-party source?
May I answer in three ways? One, no, we have not gone through the hypothetical of selling them. Other than at a cursory level, we don't think it works. Two, any outside investor is going to price in the risk factor. Oahu by itself has wildfire risk we need to address, and we've remained dedicated to addressing this problem for all of our customers across all the counties. With respect to co-ops, we have great respect for KIUC. They do an awesome job. I think this fire has proven why you need an equity layer under. I mean, the fact that we're paying the $2 billion, in their own testimony, they recognize that liability risk. Co-ops would not be in a better position to deal with this liability, in my opinion. Yeah.
But how do you know unless you tried?
I mean,
they'd be in a better position to have access to lower cost capital, though.
Yeah, I mean, I defer to them. In their testimony, at least in the original version, they clearly called out that they could get FEMA funds to recover their equipment, but they're also exposed to the same liability risks. And when you look at what's happening in California right now, you have two very tragic, devastating wildfires. One is in Palisades. It's served by a muni, not a co-op, called LADWP. And you have one in served by Southern California, which is an IOU. One is participating in the fund, one is not. And we don't know how this will play out, and I'm not speculating who's liable, but in the hypothetical, Southern California, an article just ran in the LA Times 3 days ago saying that the fund has allowed them to avoid a fatal blow to their financials. It appears to me, and if a muni or co-op was held liable, that would fall straight down to their customers. They don't have the ability to get investors to provide $2 billion in dilution to pay for the claims. So I forget who asked the question.
Sorry, KIUC is on. Can KIUC weigh in on the co-op question, whether you think it would be viable? I feel like you guys are, maybe the best person to ask.
Yes, thank you for the question. I think to Representative Lowen's point, for KIUC, we would have, insurance, we would have potentially FEMA reimbursements of up to 75% of losses. We also have insurance that would cover some, and then we would also have, to her point, access to low interest lending, potentially up to $100 million. Beyond that point, it would become problematic to us. I guess the question is, what is the magnitude of the loss, and then how would we address it? But we do have various funding sources as a cooperative, which are the FEMA reimbursements and the low-cost lending from our U.S. and other cooperative lenders, and that we would have access to.
So any potential investor or group of investors buying any of the neighbor island co-ops would have that factored into their price as well. I'm assuming these kind of advantages of a more rural electrical co-op. Is that fair?
In general, yes. That's one of the advantages of a co-op, is that they are, a not-for-profit. They do have the ability to access FEMA funding, and they do have the ability to access those low-income or those low-cost debt providers, such as the rural utility services. Yes.
Okay, thank you. Rep. Iwamoto?
This is for Hiko. So it's clear to me, I think you stated very clearly how we're going to raise the ratepayer funds, but in terms of the shareholder funds, even though Representative Lowen asked the question, I didn't hear a clear pathway to raising their share, whatever size their share is.
Yeah. Thank you for the question. I'll try to be clear. We don't think it's feasible to raise additional funds over the $2 billion we have to raise to do with the settlement, to contribute to the fund, which is why we find the amendment problematic. It would certainly delay, if not prevent us from participating, which would negate its benefits to property owners, insurers, renters. It would negate its benefit to customers because we would be assured of not getting our credit rating restored. And it's an issue. We have a lot of work to do to address wildfire safety.
Okay.
We just filed a huge application to do a lot more work to mitigate wildfire safety.
Thank you. Is the Attorney General here?
Yes, they are.
Hi. Thank you. Chair, may I ask?
Yeah, please. I've actually got a question for
Yeah,
you too.
thank you. So regarding your concerns, specifically insufficiency of monies in the fund, you basically lay out the fact that the way that the HD1 is currently drafted, that if there's an insufficient amount of funds, that the utilities get payments, but the claimants, if there is insufficient funds, they just don't even get a claim. So they're ratepayers are putting in, but they won't be able to file a claim.
That's correct, as the bill is currently drafted.
Right, okay, that's a problem. Yeah, thank you.
AG, stick up there for a sec. On page 14, line 15, we are excluding government entities from making a claim. Page
Yes.
14, line 15. What's the purpose of that? I mean, if a government public housing project burns down, shouldn't the government be able to get reimbursed from this as well?
We believe so.
Okay, so you would advocate for removing that exclusion?
That's correct.
Okay, and I've got a couple more questions for you since you're up there anyway. And this is just clarification. I'm pretty sure this is the case, but the limitation on liability in this bill, it does not affect personal injury. Is that correct? It's just property?
Yes.
So if a person was injured in a fire and their house burned down, their economic recovery could come through this fund, but they could still sue in civil court for the personal injury? Is that
That
fair?
appears to be the case.
Okay. There is language in here restricting all claims coming from, if they fail to file a claim, all other claims in civil court. It seems like a little ambiguous whether that would encompass personal injury or not. Was the intent to not include personal injury at all in that failure to file a claim provision?
It is ambiguous, and it does raise constitutional questions.
Okay, I agree. Sorry, last question for you. Section A3, subsection G. I don't have a page number for you, I'm sorry. But it allows retrospective payments specifically after a wildfire occurs. I got to admit, I don't understand the purpose of that. Is that allowing a utility to make retrospective payments after the fact to jump into this wildfire recovery fund? A3G.
I'm not sure about that provision.
Okay, does anyone else here have any thoughts on that provision?
Sure, can you repeat?
Yep, section A3G of the bill. Bottom of page 11.
Thank you.
I'll give you a sec.
Thank you, please. Sorry, please, thank you. Yeah, I think I understand the question.
Okay.
Part of the bill envisioned, if we didn't get securitization, was there another path? We don't really think that's good, but what it was is we had to elect into the fund, and if a fire occurred before we fully funded it, that we could continue to replenish the fund. But I would verify that with you and follow up. But I believe this was a provision in this design to cover us in the event that we got the fund without securitization, and I will validate further that with you offline. So there was some notion that we might be agreeing to participate, commit to participate, but still be in the process of making our initial contribution. And this would have allowed us to act as if we were in the fund and start making those payments against the fund after a fire occurred.
Okay, that does make sense. Thank you.
Thank you.
Any other questions?
Just
Yes,
really
please.
quick, sorry.
Oh, I'm sorry. Rep. Todd's been waiting a while.
Thanks. I'm looking to be educated a little bit. Is there a provision in the bill that would allow for inflationary adjustments to the size of the fund? And then if not, in the future, assuming this goes through, would you need additional legislation to adjust the cap, or would that be strictly through the PUC process?
So let me try to address that. Very good question. The intent is that the initial $1 billion would be funded immediately and that it would grow in interest. So, if you use 5%, it would be worth 1.6. So that's the hedge against inflation. It's also a return to customers if we can do our job and reduce wildfire risk. And by say our job, not just utilities, but all across the state, bring down the risk in land use, land management. So it would return back. There is a function of the bill that allows the executive director to say, we've looked at the risk and it's going the other way. You must make a supplemental contribution at that time. But, it's our intent to continue to drive the risk down.
And that would not require additional legislation, at least theoretically?
Theoretically, no. It would be part of the administrative rules process. So, thank you.
Rep. Lowen?
For Hawaiian Electric, just going back to the amount, the split between shareholders and ratepayers.
Yes.
I mean, are you saying that if it's the $500 million that we have in there now, or really any amount above the $5 million that you first proposed, that you would rather have us not pass the legislation? Or like what's your?
I'm not saying that. Oh, sorry. Let me let you finish.
Yeah, no, go ahead.
Yeah. No, that's not what I'm saying. I think certainly we can go back and continue to look at it, but I'm telling you definitively that in my discussions internally, it would be exceedingly difficult to make any significant contribution on top of what we're already dealing with. So, our market cap today is probably around 1.7. We cannot ask investors to go. There's a finite amount of money we can get from investors. Right now, they've suffered less than 8% returns for the last 5 years, and they're facing the possibility of losing it all. So, we just don't have the capacity, respectfully, we don't have the capacity to raise something that's going to make a real dent in what you folks are looking for. Yeah. But we do want it to pass. We want to continue the discussion and try to make our case. Yeah.
Okay, and really quick question for a consumer advocate.
Yes.
Just noting, and sorry, I should have caught this sooner, but KIUC was asking for an amendment requesting to put something in this bill to allow them to authorize the recovery of prudently incurred wildfire mitigation plan related costs by an electric co-op. Is that something we should do in this bill, or is it?
I think that's something that would be handled on the regulatory with PUC.
That's something they could
request. They could file a request with their
separate.
wildfire mitigation
Okay.
plan.
All right, thank you.
Any other questions before I go on? Okay. Sorry, AGs, I thought I had, if you could come up for one more question. This may not even be your question to answer. Section 8A1. What page is that on? 8A1. This limits the recovery amount to 50%. I'm wondering why it's 50% and not 100%. And if this is more of a HECO question, you can just.
This is a HECO question.
Okay. It's passing the ball. Page 17.
Thank you, Chair. There are two functions. Oh, do you want to restate, or? I got
please.
it. Okay, so the cap is flexible. It's defined as the greater of, right? So really the important part is that it's the average assessed value of the county times the structures destroyed. It is what we think is objective, fair, and proportional. So it slides its scale up and down. And that's probably the one that will kick in a really catastrophic fire. The 50% is really, there is an odd circumstance where 50% of the fund might be higher. So it's always to the benefit of the property owner. It's a weird scenario that we played out that we wanted to make sure it was always the larger of the two, if that makes sense.
So that could be 70, 80%. It usually wouldn't matter, is what you're saying. Could even be 100%.
Usually would not matter. There is a weird case where the number of structures, it's an edge case where the number of structures destroyed times the average value in the county is actually the lower of these two numbers. So we're just trying to give the largest possible reasonable cap to customers.
But in that case, I mean, if we're talking about averages here, wouldn't that, you're calculating averages based on, well, I guess it's the county.
It's the county.
I take that back.
Yeah. So
Okay.
we could run some scenarios for
So
you.
it hits
We
like a
ran
richer part of the county, even though the county's aggregate value of the homes is here, the portion of the wildfire destroyed
Could be
area
bigger.
could be
So the
here,
fund's
and
going to
then-
grow, right? So let's say
Okay.
in 9 years, it's 1.5 billion. You could find a situation where you want the greater of these two caps. That's all it's doing, right? So if the fund grows and we end up in a situation
Would there
where,
even be a 50% cap then in that case? I mean, do you really need one there?
again, if we use just the other cap, the 50% could be greater. This is really designed to provide the greatest benefit to property owners. It's all,
Okay.
yeah, I mean,
Okay, I see what you're saying.
Yeah.
So that 50% could be moved up. I mean, how did you land at 50?
it has to do with, we really just wanted the second function, but we wanted to make sure that we were being as balanced as possible.
Okay, but you guys must have run the numbers because you ran multiple
We
scenarios.
did. I don't
Is
have them on the top of my head right
Is
now.
that how you got to the 50 though, by running those numbers, or because 50
Frankly, I
seems like
think we just looked at it and said there's this weird condition where this might unbalance our objectives and not be as beneficial to property owners. So we wanted to make sure there was no condition where it was less than 50% of the funds in the event of a fire. Yeah. I mean,
Okay.
the key point is it's the greater of the two, right? So it's only to the benefit of the public that it's the greater of the two.
Okay, thank you. PUC. So for section B2, subsection E, it sets considerations for approving the bond. And the previous committee put in a provision I like, which is a kind of a catch-all provision. My question is for the other ones, for the non-catch-all provisions, are these similar to what you would normally consider when approving a bond, or are these dramatically different? I just need some kind of benchmark here.
Make sure I got the section you're looking at.
B2 subsection E. Page 39.
Thank you. Yeah, it is the typical way for crime, but then the non-catch-all, right, is what you're trying to get at.
Yeah. So the catch-all is what you would normally consider, but then the non-catch-all provisions are additional to what you would normally consider.
Correct.
Will that sway, because you have to, if we kept the bill the way it is, because we put in those criteria that you'd have to consider, would that sway PUC one way or another when considering granting this bond or authorizing this bond?
No, I think for us, we always like to see as much information as we can, and we would try to balance that, right? I mean, it doesn't really sway. I mean, it's more for information that we don't not get that information, which then could come up with a decision, right, that you didn't look at everything.
Yeah, my concern would be that if you have to balance these factors and these are other factors being put in that you wouldn't normally have to balance, whether that would sway you. But what you're saying is you're going to look at all of these just for consideration purposes and then make a determination anyway without any kind of weighted value.
Correct.
Okay, thank you. Is B and F here? Okay, this might be an AG question then. They do have a question, and I have no shame throwing this one to Finn, by the way. So if you can't answer, don't worry about it. But on section 5 on page 58, there was some concern in the testimony that this section would affect the state's bond cap. And one of the testimonies was concerned that this would necessarily obligate all of the state's bond cap for the next years in the future to fund this securitization. I'm not sure I totally understand it, but do you have any insight onto that?
Yes. Presently, as the bill is drafted, it requires or it authorizes the use of the state's private activity bond cap, the state's portion, for this securitization process. Right now, the administration and the statute presently provides that the state's bond cap is to be used for rental housing, low-income rental housing purposes. So by authorizing this change, the legislature is preempting that move. Instead of low-cost housing, rental housing, it would go to securitization.
So it would eat up the whole bond cap? Or
Yes.
We would have no money in the bond cap for low-cost rental housing?
That's correct.
How much are we talking here, you think?
I don't know.
Yeah, that's fair.
Follow up on that?
Yeah, please,
Sorry,
Ripple.
I thought that provision was the request of the AG to put in, or as a, sorry, am I mistaken? Like, I thought that provision was just another alternative pathway to achieve the same, but to borrowing that would allow HECO to have access to like the cheapest options, but not that it was necessary to the rest of the bill.
It was not an AG provision.
Okay. HECO. Sorry, really quickly. I'm sorry. Was that, no, but that was one of the amendments that was later. It wasn't added, but it was an amendment that you guys made towards the end. Okay.
Yeah, we'll clarify, but Representative Long, we think you're correct. This was an alternative on 39, I mean, this is an alternative way to do it that was put in at we'll clarify how it came in, but yeah, it's not the primary vehicle.
So it can come
Yeah.
out. Okay.
We believe it can still come out, yeah.
Okay, I think we consider it out then. I have a couple questions left for KIUC. Before I start, though, anyone else have any questions? Okay, KIUC, are you still there?
Yes.
In your
Thank you.
testimony, you requested an automatic tariff provision. Why can this be just requested from PUC in the normal course? Why do you need it
Right
here?
now, the only way to do this would be through a general rate case, which is extremely expensive and takes quite a while to adjudicate with the PUC. So we do not have separate recovery mechanisms. HECO does have some. They have decoupled rates, so they have the ability to do this type of thing. We currently do not. So the thought was not. And the thought is not to bypass the PUC because the amendment would require the establishment of the mechanism to go through the PUC.
Okay. So does KIUC plan on participating in the wildfire recovery program?
We, as far as the fund, we appreciate having the option to participate, but I think we would need to better understand what our contribution might look like and whether that would be the best use of our funds. So we do like having the option, but we would need to explore it further to decide whether or not we would participate in the fund.
That's fair. Options are good. In reading the bill, and maybe you could shed light on it, or if you can't, then HECO could or someone else can. But it was not clear what the contribution from KIUC or another utility would be to this fund. We're laying it out for HECO as like a 500 million or a billion, or whatever number we put in there. But for other utilities buying into this thing, what would their obligation to the fund be? Do you have any idea, since you guys were considering it?
No, we understood the intent was for the executive director, I guess, would work with other parties interested in participating on an appropriate level of capitalization of the fund.
In that case, shouldn't HECO also fall under that? Shouldn't the executive director also make that determination for HECO?
That I can't say. We didn't
That's fair.
author this bill, but I think that, HECO, had an idea for the framework and what their contribution should be. We, again, would not, it's not guaranteed that we would participate. So,
Okay.
Again, as we like the optionality, we would definitely need to explore it further.
Okay, thank you. Spectrum, do you have any thought on that? On whether you guys are going to be participating in this fund and what your contribution to it might be?
We've looked into it, but we don't think we should be participating in this fund. We're not a rate-regulated utility.
Okay, thank you. HECO, do you have any thoughts?
Thank you, Chair. Yeah, KUC is correct. As it's currently designed, Hawaiian Electric's amount would set, and then the ED would stand up a whole process to address some of these issues. We attempted last year to involve a number of parties. The feedback we got was make this simpler. And so that for a lot of reasons, that's why it calls for the establishment that will fund to stand up an executive director and to establish administrative rules, and then offer opportunities based on other people's risks if they want to contribute. It also allows the ED to declare that there needs to be supplemental contributions. So yes, last year we had a bill that attempted to bring all the parties together and allow for contributions from government, from other utilities. This year what we're saying is we want to leave the option open for them and make it part of the stand-up process with the ED.
Okay, my concern is that we're trusting the ED to make these determinations for other utilities, which I'm not against, but we're setting yours in stone. Would it be fair to allow the executive director to adjust your contributions as well if they determine it necessary?
It's something we could consider. It's not what we contemplated. We think the amount is the right balance right now, and we think there's urgency to get it stood up.
Yeah, and putting it in statute now, or putting it in the bill now for the initial amount, I think is fair, given the sense of urgency. But whether that can be adjusted later, especially putting, that's what we're asking for all other utilities.
Right.
That seems odd to allow the executive director to adjust everyone else, but not yours necessarily. It could be down, I mean,
Right.
I'm not saying we have to move it up.
Yeah, it's a great point. I think it allows for it currently to make supplemental, so the ED could say supplemental or adjust the risk down. I think that's part of the process. And I think for the other utilities, it will remain optional. And we're open to working with Spectrum or KIUC on it, but right now the bill calls for that process to occur. We stand up now. If the ED wants to adjust, our ability to participate we'd have to make that decision. It would then become optional for us too if it was too severe. But yes, I think the bill, and I think we can verify, but yes, it allows for it.
Okay, if they adjust it down, what happens to the money?
Return to customers.
Okay. That's all my questions right now. Members, any other questions on this bill? Okay, give me 1 second. Let me just do a quick. Oh, you can sit down.
I can sit down.
Yeah,
Thank you, Chair.
Okay.
So they're gonna have to come back after.
Okay. We'll recess until you come back. Shoot, where am I? Sorry, I have one more question for AG. We're going to move this thing, or the deadline for this, but there is a deadline set for, I believe it would be established by the executive director, but a deadline set for when someone would have to file a claim. My concern is that after a large wildfire incident like we had in Lahaina, residents may not be in a place to file claims in a more timely manner. I wanted to set a minimum amount of time to give them. In discussing with Chair Tarnas, we were thinking 2-year statute of limitations for property, maybe double that, 4 years for them to file a claim. If the statute passes, they may not be able to file in court anyway, but at least they'd be able to file a claim for it. What would you think is a ballpark minimum deadline for filing a claim?
I couldn't say. It would relate to the circumstances of the incident.
Okay, so do you think that the executive director should have the ability to kind of be more flexible on this, or?
That I couldn't say.
Okay, thank you.
And with respect to your previous question on the rental housing bonds, sections 4 and 5 have to be read together.
Which page are you on?
This is on page 57 and 58. This is for
We're talking about the bond.
HECO decided to use special purpose revenue bonds. Special purpose revenue bonds would use the available private activity bond cap. So this would only kick in if special purpose revenue bonds are used for securitization purposes.
Okay, so it wouldn't eat up the bond cap necessarily if we read Section 5 by itself. Section 5, in conjunction with Section 4, would limit Section 5 to just the SPURBs issued by under Section 4.
That's correct.
Okay, that makes sense. No, thank you for that. Did anyone else have any thoughts or questions to follow up on that they want to contribute before we recess for a sec? Okay, all right, well, recess. reconvening for decision-making on House Bill 982 HD1. Thank you to all the testifiers for testifying as well. We do appreciate you being here. Chair's recommendation on this bill is, well, we've got a bunch of them, so buckle up. Interest earned on the securitization amount must be refunded annually to ratepayers through credit on the ratepayers account. We'd like to require that there be no less than a 4-year deadline for claims submitted to the Wildfire Recovery Fund from any incident to address the concern that a person failing to meet the deadline would be unable to pursue their claim in court. In Section A5, we're going to keep it with the PUC to determine whether the contributor acted prudently and for the amount of the order for the replenishment. But the $5 million set aside specifically for administrative costs should be used by the executive director of the Wildfire Recovery Fund to hire consultants for the PUC as needed to make this determination. We'd like to add language that the Wildfire Recovery Fund is a trust fund per the AG's testimony, just to specify that. Specify that the executive director of the Wildfire Recovery Fund is responsible for establishing the fund's investment policies. In Section A3, subsection B, subsection 2, I do want to break out the $5 million for administrative costs and specify that it is from that amount after 2035 that any remainder will go to the fund. But just breaking that out from the $505 million, it'll now be $500 million and then the $5 million separate, just to be a little clearer. At the PUC's discretion, when HECO comes in for securitization, we'd like to give PUC the discretion to also tack on that there will not be any increases in executive salaries at HECO for a period of 5 years, but also at PUC's discretion from the start of securitization, and that any bonuses earned by HECO executive during that time would instead go to the Wildfire Recovery Fund. Section A9, subsection B, we are going to add language excluding existing indemnity agreements from this provision. Page 18, line 5, which is section A8C, I do want to specify that this is for all civil claims for qualified damages. Right now, it's a little bit unclear as to what this section applies to. Members, any comments? Yep, Rep. Iwamoto.
Do you mind clarifying, is the fund now 500 million total? So is that what you said? I heard you say 500 million, but I couldn't.
The current split is not going to be changed. So it's 500 million, 500 million. But one of them was 505 million because the administrative fees were added onto that. So we're separating out just that 5 million from the 505.
Thank you. Thanks.
Yep. Yeah, Rep. Belatti.
Clarification, you said you were going to clarify the civil damages to all civil damages related to property. You're not opening it up.
So the question was for the last one, right? You're talking about, right now it says civil claims. We're adding it to specify it's civil claims for qualified damages, and qualified damages is a defined term.
And qualified damages is limited to property damage.
Yes.
Okay, thank you.
Any other comments? Okay, if not, Vice Chair for the vote.
Members voting on House Bill 982, House Draft 1. Chair's recommendation is to pass with amendments. Chair and Vice Chair vote aye. Representative Iligan.
Aye.
Representative Ichiyama.
Aye.
Representative Iwamoto.
With reservations?
Representative Kong.
Aye.
Representative Lowen.
Aye.
Representative Martin.
Aye.
Representative Tam.
Aye.
Representative Pirik is excused. Chair, your recommendation is adopted.
Okay, thank you, members. And I do want to thank the chair from the previous committee, too, for her hard work on this.
Moving on to Judiciary and Hawaiian Affairs, same recommendation that we heard from the CPC chair, HB 982 HD1 with amendments. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 982 HD1 with amendments, Chair and Vice Chair vote aye. Representative Belatti.
Aye.
Representative Cochran, excused. Representative Hashem, excused. Representative Kahaloa.
Aye.
Representative Peruso.
Aye.
Representative Takayama.
Aye.
Representative Todd.
Aye.
Representative Garcia, excused. Representative Shimizu, excused. Recommendation adopted.
Thank you.
Okay, thank you. We are adjourned.